In this video, I'm going to do an introduction to commercial liability insurance. While most of this video comes from the CPCU Commercial Liability Risk Management and Insurance Text, Assignment 1, you won't need the text in order to do well on the exam. In fact, the entire exam comes from this Prezi video and the Prezi itself. To get started, let's look at how a legal liability arises. To understand and appreciate the need for liability insurance, you must understand how and when a liability arises, as well as what types of liabilities are actually insurable. But first, realize that every person and organization is exposed to a potential liability loss, and in fact, liability exposures are greater than property exposures for organizations. This is because every organization has some exposure that is not property. So while your property exposure is limited to the value of your property, your liability exposure is your total assets. That might even include future income. Legal liability can be imposed by civil or criminal law. Let's look at that a little more closely. So we'll talk about civil law versus criminal law and insurance here in this section. Insurance is actually prohibited by law to insure criminal acts. A single act, however, can be both civil and criminal. So a loss can be a criminal wrong or a civil wrong, and the insurance would respond to the payment for civil damages. Therefore, insurance can respond to an act that is both a civil and criminal wrong in some cases. Let's look at an example. Let's say a drunk driver causes an accident that results in the death of another driver. The drunk driver clearly committed a crime and would probably have to pay fines and maybe even do jail time for that crime. But in addition to that, they committed a civil wrong. The damages resulting from the death of the other driver would actually be insurable under the drunk driver's auto insurance liability. But what you should understand from this section primarily is that criminal wrongs are not insurable in and of themselves, but a criminal wrong that is also a civil wrong is possibly insurable. You should realize, though, that insurance excludes losses that were intentionally caused. So in many cases, a criminal wrong results in an intentionally caused loss. Now let's talk about the basis for legal liability from a civil wrong, since we've established that most insurable risks result from civil wrongs. And those are torts, contracts, or statutes. Let's look at these individually. We'll start with torts. A tort results when one person or organization invades the legally protected right of another. This is a pretty broad definition, and it has a broad range of meaning. There are three types of torts: negligence, intentional torts, and strict liability. So let's look at each one of these. You may remember this from a business law class or even from Risk Management 2005. Negligence is based on 4 elements in order to give rise to the legal liability. Actually, the first 2, a duty owed to another person and a breach of that duty, constitute negligence. But you have to have proximate cause, which is a close causal connection between the breach of duty and any resulting harm, in order to give rise to a legal liability. Additionally, there has to be an occurrence of actual, measurable loss or damage that is recognized by law. So even though a duty was breached, and that duty is the proximate cause of some sort of pain and suffering of the individual, there still has to be actual, measurable loss. Now let's talk about intentional torts. An intentional tort is a tort committed by a person who foresees or should have been able to foresee the harm to the other person. Examples of this include false imprisonment, larceny, assault, slander, libel, and advertising infringement. Oftentimes, these are not insurable. They're excluded under insurance policies. However, again, it goes back to this concept of an intentionally caused loss. If one of these has been conducted and a loss arises that wasn't intended, such as you unintentionally slander someone or you intentionally slander them but don't mean for the harm to occur, in some cases these types of losses are insurable. Strict liability. This is a special class of tort. This is where liability is imposed without regard to negligence or the ability to foresee harm. In other words, for the injured party to receive damages from the tortfeasor under strict liability, they don't have to show that the tortfeasor, the person from whom they're seeking damages, was actually liable. There simply has to be an existing relationship that results in strict liability under the law. The law that this comes from include statutory law and common law. We'll look at both common law and statutory law here in a moment. But examples of this include workers' compensation, where an employer is strictly liable or absolutely liable to employees that are injured on the job without regard to the employer's negligence. The manufacture of dangerously detective products, such as a non-working smoke detector, where if a person buys a smoke detector, installs it, and the smoke detector fails to work and detect smoke, the resulting damage from fire would have to be covered by the manufacturer without regard to the manufacturer's negligence. And lastly, an ultra-hazardous activity such as blasting or imploding. This is an operations liability exposure that would actually be considered strict liability because of the nature of the activity. These are commonly insurable. So that was liability that arises from torts. Now let's talk about contract liability. A breach of contract might also create a legal liability, but it is not a tort. Examples of this include a warranty in a contract. For example, if the warranty states that the product is fit for a particular purpose, then the product fails and the buyer is injured as a result, the manufacturer may be held legally liable. Also, a hold harmless agreement, where one party agrees to indemnify another party in the event of a liability. These are common between landlords and tenants and contractors and owners. For example, a tenant may agree to not hold a landlord liable for the injuries or damages that occur on the tenant's rented property. I'll give an example of contractors and owners in a few minutes. Statutes also can give rise to a liability. A statute is a written law passed by a legislative body at a state or federal level. Written laws at the local level typically are called ordinances. Ordinances also can give rise to a legal liability. Statutes and ordinances might modify duties to others, which thereby might create a liability because once you've elevated or escalated the duty to someone else, you've made it easier to breach that duty and thereby become negligent. An example is workers' compensation, which is also, as I mentioned, absolute liability in tort or strict liability. But workers' compensation is a statutory law, and the workers' compensation statutes are what makes workers' compensation strict liability, which, as I said before, is also known as absolute liability. Before we turn to a discussion of insurance and legal liability, I want to mention one other aspect of the basis for a legal liability. This is known as the important concept of common law. This is where rights and duties are shaped by court cases over time. Examples include the right to trespass and the duty to a trespasser on your property. In other words, the duty you owe to a trespasser. Not only has this evolved over time because of changes in court case outcomes, but also it varies from state to state. Next, the duty to preserve the reputation of another and freedom of speech. This is changing quite rapidly and being reinterpreted with social media and other communication outlets becoming so popular and so much used. Now let's look at insurance and legal liability. Most insurance policies obligate the insured to defend the insured in a lawsuit. Generally, this is covered in addition to the policy limits. In other words, the defense costs don't use up any of the policy limits. Therefore, there might be a loss under the policy even when the insured isn't liable. This is because the insurer might have to engage in a defense, pay lawyers, and even court costs. Even if they win and don't incur a legal liability, they would still have a loss because of the defense costs that were incurred. The reality is that most liability claims are settled. In other words, they're settled out of court, primarily to avoid the expense of a costly court proceeding. Now let's talk about commercial liability loss exposures that are common. Let's start with premises and operations liability. This is liability arising from a bodily injury or property damage arising from an accident at an organization's owned, leased, or rented premises or out of the organization's ongoing operations. One of the most common examples of premises and operations liability is a slip and fall. If a customer or even trespasser or just a visitor slips and falls on your premises, it's likely that you'll be liable even when you have a hazard sign put up. The duty that is owed to visitors to your property depends on the status of the visitor. This can be anywhere from a trespasser to an invitee, where an invitee is generally someone that comes onto your property for your benefit. This is sometimes viewed as strict liability, such as with the inherently dangerous activities like blasting and imploding. Then there's products liability. Sometimes this is treated as part of products and completed operations, but because it has so many distinguishing characteristics, I'm going to talk about them separately. Many products liability lawsuits have also been treated as strict liability. The manufacturer's negligence becomes irrelevant. The focus is on the safety of the product itself. Toy manufacturers, lawn tools, and other mechanical household tools are commonly treated as strict liability. But in order for an injured party to find the manufacturer legally liable, 3 elements must be proven. First, the product was defective when it left the manufacturer's or supplier's control. There was a defective condition that made the product unreasonably dangerous, and the defective product was the proximate cause of the injury. So in a sense, because these things must be proven, so even though this might be thought of as a strict liability types of exposure, because these 3 elements must be proven by the injured party, the manufacturer does have several defenses to negligence, and it really isn't truly strict liability. Then there's completed operations. The legal responsibility of a contractor, repairer, or other entity for bodily injury arising out of the entity's completed work is the completed operations exposure. I want to mention the accepted work doctrine, though it's no longer commonly enforced. Under the accepted work doctrine, a contractor cannot be liable for negligent completed work once the owner had accepted the work. Because of this, it was the owner's responsibility to check and make sure that the work was completed as expected and that it was safe. However, numerous exceptions to the doctrine have been made, and some courts have abandoned it altogether. Auto liability is another possible exposure for a business. An important question with auto liability is who is liable for damages and injuries from an auto accident. First of all, we know that the driver of the vehicle causing the accident is liable if they're negligent. The owner of the vehicle who has given the negligent driver permission to drive his or her vehicle is also potentially liable. Additionally, the organization legally responsible for the negligent driver's conduct is liable. So if Mary is asked to deliver some papers for the law firm she works at, and she has an accident in her own car on the way to do this delivery, the law firm, her employer, would actually be vicariously liable for the negligent driver's conduct. If Mary was actually driving another person's vehicle with the permission of that person, they would also be potentially liable for damages from the accident. However, if Mary goes a different direction and decides to, say, for example, get a cup of coffee on a street that wasn't part of her route to run the errand for the employer would not be legally responsible for the negligent driver's conduct. In this case, Mary's. Some states also have no-fault laws that require an insured's own insurance to pay for damages that would otherwise be covered under bodily injury liability. Typically in those states, there's a threshold where once damages go beyond that threshold, such as $10,000 or $25,000, then the injured party can actually sue the negligent party. Workers' compensation and employers' liability are also a significant potential exposure for most businesses. Workers' compensation, as I've said before, is statutory. Benefits are laid out in state workers' compensation statutes and in certain federal statutes, such as the U.S. Longshore and Harbor Workers' Compensation Act, which is primarily for longshore workers. There are similar federal statutes for other industries like the railroad. These statutes require the employer to pay or insure medical, lost wages, survivors, and rehabilitation benefits in most states for injuries and illnesses contracted on the job. It's supposed to be no fault or strict or absolute liability, and it's also supposed to be the exclusive remedy, which means it should be the only remedy for injuries incurred on the job. But there are exceptions covered under employer's liability. Let's look at those. These are when the exceptions to the workers' compensation being the exclusive remedy exist. These include injuries that were intentionally caused by the employer, claims for the employee's spouse for loss of consortium because of the employee injury caused by the employer's negligence, and injuries resulting from the employer's negligence while acting in a capacity other than an employer. For example, if the employee is injured in a weekend baseball game and it's because of his boss's negligence, the employee could sue the employer for those injuries. Also, workers' compensation doesn't cover management liability types of torts, such as age and sex discrimination. We'll look at that in a moment as well. There are certain hold harmless agreements, as I mentioned before. Hold harmless agreements are common among both contractors who have employees and landlords who have tenants. An example: Randy is a building contractor hired by Sammy. Sammy makes Randy sign a hold harmless agreement, agreeing to hold him harmless or not liable for any injuries while Sammy's building is under construction. Destin, who is an employee of Randy, is injured while working for Randy on Sammy's building. The injury resulted from an unsafe condition that was Sammy's fault or because of Sammy's negligence. Destin successfully sues Sammy, thinking he can get more from him than he could from workers' compensation. Randy has to indemnify Sammy for the damages from the suit against her because of the hold harmless agreement. In other words, Randy ends up being responsible for the damages even though Sammy was negligent. Before we move on to risk control, I want to look at some other commercial liability risk exposures. First, management liability, which I mentioned before. This includes both directors' and officers' liability when a director becomes liable or officer, generally to shareholders, but sometimes employees. Another example is employment practices liability, or EPL, which is covered by EPLI, Employment Practices Liability Insurance. This is another big area of exposure for businesses that have employees. This would cover things like age discrimination, sexual harassment, and sex discrimination. Professional liability is a huge exposure for certain organizations. For example, in the medical field, the area of healthcare professional liability, which pays for injuries or damages that are caused by the healthcare professional's actions, and errors and omissions, which is common for insurance agents and sometimes lawyers and accountants and other financial advisors, where, again, the client loses money because of some mistake made by the professional. Then there's environmental liability, which primarily covers damage from pollution, and marine and aviation liability, which is a whole category in itself. Now let's talk about risk control for commercial liability exposures. Let's first establish a foundation for risk control. Risk control should be a key part of any organizational decision-making process. This is a diagram from the CPCU text, and it just shows that all of these different things need to be considered in a project decision: engineering, logistics, risk control, tax departments, human resources, and finance. So risk control is a key component, or should be a key component, in the project decision. But why is liability risk control so particularly important? Well, liability exposures, of course, can result in the death or serious harm to individuals, to employees, to customers, and to visitors. Liability losses can also result in significant financial consequences. These, as I said before, are even greater than an organization's property exposure. Also, poor safety and other liabilities can hurt an organization's reputation. So the exposure goes beyond just the legal liability and the financial consequences. There are numerous stories about organizations such as auto manufacturers and drug manufacturers where the organization has either benefited from positive risk control or been severely hurt by negative risk control. Think about Tylenol, which was a positive experience, and the BP oil spill, which is very negative. Risk control is just as important with small and medium-sized businesses as it is with large businesses, though it often isn't seen as a high priority for small and medium-sized businesses, or sometimes ignored entirely. Management support from the very top is vital to the success of risk control. First, it adds credibility to the risk control program. It helps to identify the root causes of accidents. If you think about it this way, when the top managers of an organization create a culture of safety, individuals at all levels of the organization are more likely to identify the problems that exist within the organization. Oftentimes, speed and safety are contrary and they conflict against each other. While speed sometimes leads to the profitability of an organization, it often makes activities unsafe. So if safety is seen as a vital part of the organization's success, then this will hopefully lead individuals to put safety first and identify root causes of accidents before the loss ever occurs. Realize that human behavior is responsible for 85 to 95% of accidents, so employees should have ownership of the risk control plan from the top down. This is the continuum of a loss exposure, a diagram again from the textbook. It's fairly straightforward. It just shows that there's first a hazard, which can be a person, property, or an activity, which may yield an accident, injury, or damage, which may yield litigation or a lawsuit. The focus on the hazard should be loss prevention, same with the accident, but at the point of litigation, the focus should be claim management. Let's look at that more closely. Let's talk about pre-accident risk control techniques and post-accident techniques. First, what are some things that need to be considered in implementing pre-accident risk control? Obviously, cost effectiveness is important. Legal requirements, such as OSHA requirements and workers' compensation statutes, must be adhered to. Insurer requirements, oftentimes the insurance policy itself requires certain risk control activities. The company image, which is becoming an increasingly important consideration. Part of this is because of the ease of publicity and global scrutiny. With social media sites like Facebook and Twitter, if a company makes a mistake, this can dramatically affect their stock price and the popularity of their product or service. Additionally, the degree of risk aversion of senior management will affect how an organization treats risk. The more risk averse, in general, the more risk control the organization will implement. Additionally, the more risk averse, the more insurance, but some exposures aren't insurable and just must be controlled. So let's look at pre-accident risk control techniques. First, loss prevention, then loss reduction, and then avoidance. All three of these are very important to an organization, but they're a bit different in their approach. Let's start with loss prevention. This disrupts the loss continuum. In other words, it removes or mitigates hazards or perils to keep losses from ever happening. It reduces the frequency or the number of times losses occur. Examples of loss prevention include using backup alarms on box trucks to warn pedestrians. If you're in Sam's or Home Depot or Lowe's, you might hear these box trucks when they're backing up or even moving forward so that you know to get out of the way. Safety glasses worn. Almost every construction site now mandates that safety glasses must be worn, and these keep any flying objects, dust, or chemicals from getting into the eyes and damaging eyes and sometimes the face of a worker. loss reduction techniques. This limits the damage or injury resulting from a loss or accident that has already occurred. It lowers the severity of loss rather than the frequency of loss. So it doesn't keep the accident from ever happening, but it mitigates the consequences of it. Examples of this include seat belts and airbags. So even though an accident has already occurred, it keeps the passengers and driver from being severely injured. Smoke detectors and sprinkler systems. Once a smoke detector goes off, generally the fire has already started and done some damage. Sprinkler systems might immediately put out a fire, but then the organization has water damage. Avoidance is the final pre-accident risk control method. This is ceasing or never undertaking an activity so that the possibility of loss is eliminated. Organizations can't avoid core business operations, but they might avoid other operations they deem too hazardous. Examples would include outsourcing hazardous operations, such as exploding or imploding, and selling or abandoning a dangerous location. Now let's look at post-accident techniques. In other words, claims management. This is mitigating the effects of losses after they occur and the claim has already been made. The key is to achieve a balance between paying legitimate claims and fighting fraudulent claims. Fighting a legitimate claim can sometimes exacerbate the claim. For example, if a customer slips and falls on the premises at a fast food restaurant and the manager argues that the customer injuries were incurred somewhere else, this can result in additional pain and suffering and possibly punitive damages. On the other hand, failing to investigate a claim can result in paying fraudulent, unnecessary liability losses. Now let's look at controlling specific types of liability losses. As part of this, an organization must carefully monitor changes in the law, both common and statutory law, and changes in their exposure. These are just some of the ways an organization can control premises liability. First, regular inspections. Let's look at a sample inspection form from the textbook. For example, some of the questions might be, are trees, plants, and shrubs protruding, or soil divots? Are the compounded areas fenced and lighted? Here's a good one. Is the hot water temperature within guidelines so that if an employee or customer uses the restroom, they're not burned? Maintenance programs are important to establish and maintain policies and procedures. Note that part of premises liability exposure is things like identity theft and cybersecurity. Think about Target. The best way to prevent identity theft is to have policies and procedures in place and make sure that your employees are following them. The next area is protection. This is making sure that things like sprinkler systems and video surveillance and other methods of safeguarding a building's occupants and property are not only installed but maintained. Next, off-premises operations risk control. This can present a significant challenge to organizations that have substantial off-premises operations because they lack the control of off-premises sites that they have over on-premises sites. Examples include construction, plumbing, and other contractors and similar types of service providers that provide a significant amount of services at their customers' locations. Then the products and completed operations risk control. While products liability is sometimes viewed as strict, manufacturers do have some defense, as I discussed previously, but it is difficult to create a safe product that is still marketable because it's difficult to predict consumers' use of products. They may inadvertently defeat a safety feature or misinterpret instructions. Also, statutes and case law with respect to products and operations is constantly evolving. And remember, the focus is on the inherent safety of products. Also, there's a potentially catastrophic loss with a product that is consistently found to be defective, resulting in a potential class action lawsuit. Next is motor vehicle liability. Risk control should focus primarily on the operation of the vehicle, since most motor vehicle accidents are caused by human error. Examples of risk control are having and enforcing a written, thorough driver safety policy, careful selection and training of drivers, substance abuse testing of drivers, and consistent disciplinary procedures. Finally, there's workers' compensation and employers' liability. Many organizations dedicate more resources to risk control of these exposures than anything else, particularly in those high-hazard industries like oil and gas, mining, and many construction industries. We already discussed that workers' comp is a strict liability or absolute liability exposure. Employer negligence is not a factor. Under workers' comp, lost wages is less than 100%, usually 66.6%, but medical is 100% and is unlimited, so this can be a huge cost for organizations with workers. The high cost and responsibility of employers to pay for work-related injuries encourages employers to maintain a safe work environment. Lastly, it's worth mentioning another important area of risk control related to technology and communication. These are interrelated and represent a significant and growing exposure for most organizations today. It's created a new category of liability as well as, in some cases, property exposure. It requires new and innovative risk control and transfer techniques. And technology and communication exposures are especially significant for organizations that conduct business over the internet. Examples of risk control include firewalls and antivirus software, which can mitigate the theft of sensitive information, policies and procedures for employees who use portable devices such as cell phones and iPads, and having a prepared and measured response to breaches of information. A few years ago, there was an issue with Applebee's after firing an employee who posted sensitive information on Facebook. The problem was Applebee's response to the firing of the employee by many people was viewed as a disaster in communication for Applebee's. Additionally, there's personal and advertising injury, which are related, but they exist even without the internet. The loss exposures include, but are not limited to, bodily injury resulting from false arrest or detention, wrongful eviction, slander, libel, and oral or written publication of any manner of material that violates a person's right of privacy and copyright or trademark infringement, which is related to the Applebee's incident. Risk control measures include policies and procedures along with employee training, and regular monitoring and review of communications, including websites. And that's the end of our discussion of commercial liability.